Part two of the basic peacekeeper training module. And what's on the agenda today, Mr. Horn?
Today we're going to look at the basics of law.
The basics of law. And if I remember rightly, you forgot yesterday during our foundation chat to talk about freedom of speech and the knowledge from generations past. Well, we're only human, we're not perfect. So please feel free to add that into today's meeting.
Right, well, what we'll do is just start with that, saying that I forgot it. We talked yesterday about where we get our rights from. And we talked about rights from the Creator. That's where our natural rights come from. And we got given observational tools. So, however, with making sense of it through our observational tools, we need to somehow formulate what we observe and express it. And for that, we need the freedom of speech to formulate the thoughts which is in our consciousness. And the second other one that I forgot was the knowledge left from generations past. This is public knowledge. It's everybody's knowledge. It's not private knowledge. And the reason for that is simply that knowledge is a cumulative process. It's not something that evolves purely on its own, or very, very rarely does something come without any prior knowledge. And therefore, because the knowledge is an incremental thing, when somebody passes away, it automatically should become public knowledge. Because we've got to minimize our impact, we've got to be good stewards to the planet, and therefore we must apply all the best knowledge that we have.
Well, we could, I'm sure we could, you and I could talk all day long today about how freedom of speech is, well, the last 18 months, that's something of the past, isn't it? And yeah, so much knowledge and truth has not just been written and shared in the past, but that's also been hidden. But that's more of a topic for conversation on maybe our question and answer session.
Absolutely, it's worthwhile stuff to discuss.
So on to part two today then, Mr. Horn, over to you.
Right, the basics of law. So today we're going to look at what is law. Yesterday, basically we defined, in the first module we defined law as literally a hypothesis that provides predictable outcome to the same set of circumstances. So it starts with observation, and then once we make logic and reason out of it and express it, and it gives a consistent output, that is how we define law. So there's two types of law. The first one is natural law, and that we covered very much yesterday, which is first module. That's natural law. That's how we get our rights, our human rights as individuals. The other type of law is man-made law. So anything that is not observable by everybody is man-made law. Now, natural law we can call by many, many names: law of creation, creator's law, God's law, endless varieties of it, divine law. And that's where the birthright comes from, and that cannot be taken from you. Your responsibility is to live life and not knowingly cause harm. So explore your conscience in the way that we expressed it in the first module. And that's your right to exist, just the same as everybody else. So in summary, that there really is what, when I talk about natural law, that's what I'm talking about. Okay, then man-made law basically is any private agreements that you reach with anybody else. My word is my bond, and that creates duties, rights, and obligations of the respective parties. And again, remember yesterday we said that to be lawful, it must be a meeting of the minds. We need to fully understand the commitment that we're making when we enter a binding agreement. Now, We touched on it in the first module. It's called a common law binding precedence. What is that? In essence, when we make every interaction is a private interaction with another human. And if we get into a dispute because of a misunderstanding, this can arise from many, many places. It could be presumptions, it could have been bad expression, or quite simply, it could have been not meeting of the minds. And where that's intentional, that's fraudulent, and knowingly is causing harm. And like we said in the first module, that we have no right to knowingly cause another creation harm. So to resolve the settlement, if we cannot do this in private between the parties, we need to go to public for public social resolution. And hence the claimant calls a court to settle the dispute. And it's up to the claimant to prove the claim, and the defendant is innocent until proven guilty. And what happens is the court will make a ruling. That ruling then becomes what's called a precedence and can be applied to similar circumstances. So the facts need to be close enough to be able to apply the same ruling. And that there is called the common law or common law binding precedence, to be more accurate. So two things have power over you. Agreements you make in private, and in society, binding settlements from settlement of other disputes. So that largely is the two types of law that we talk about. Again, I'm avoiding legal because we'll explain in later modules what legal is. So is that clear enough, do you think, or does that need?
Yep, the only thing I'm happy to clarify, it doesn't matter that you used the word yesterday instead of training module number 1, because we actually did record training module 1 yesterday anyway, so you're not telling any lies.
Right. Okay, what we're going to, again, with the basic law, we're going to look at the breach of peace, which is something that we covered yesterday, but everything stems in a breach of peace. And so it's important that you understand and really get to understand this concept, because we're all entitled to the peaceful coexistence, and we all have an obligation to uphold the peace. So we must behave ourselves, and when we see others not behaving themselves, we must stop turning a blind eye, and we need to stand up and uphold the peace. So, like I said yesterday, any unlawful claim is a trespass on you, and that's called a breach of peace. And again, like I said yesterday, there can only be 3 grounds for breaching the peace. One, that harm's been caused to another, that somebody intends to cause harm to another, or that you've breached an agreement that you've entered into. And the important point about it is, at the time of breaching somebody's peace, the person that is creating the breach of peace must have reasonable evidence to show you at that time. They cannot collect evidence afterwards. So before they breach somebody's peace, you must have the evidence, and that must be reasonable evidence. So how do we define reasonable evidence? Basically, at the end of the day, if it's a criminal matter, then it's something that needs to, beyond the shadow of a doubt, from the jury, needs to meet that test. And if it's a civil matter, on the balance of probabilities. So whatever somebody approaches you, those are the tests that you apply. However, above both of those stands for a request to be lawful, it must meet 3 tests on its own. So it does not matter what the crowd thinks, i.e. the jury. Lawful is down to logic and reason, like we said yesterday. So the aim or the intent of a request must be legitimate. There must be a good reason or asking another to do something. Secondly, the claim must be probable. So this means that you need to be able to explain with logic and reason the cause to give the effect of the command that you want followed. And finally, all alternatives must be considered before picking an alternative, and the least intrusive on the individual and society is the one that must be chosen. And failure to do so under the common law binding precedence, now that we all know what a common law binding precedence is the settlement of the dispute between the Council of Civil Service Unions and the Minister for the Civil Service, where Lord Didcot simply said, irrational and so unlawful. And then he defined that to simply mean so outrageous in its defiance of logic or of accepted moral standard that no sensible person who would have applied his mind to the question to be decided could have arrived at it. So that's actually saying it does not matter what the crowd thinks. It's actually logic and reason that determines lawfulness. So that's supreme. And that reflects the rules of equity. And in what the first module was said, simply to lie is to go against the mind. Any request that is not based in truth is unlawful. And just a quick reminder, because equity is what it's all about, and that's what we're advocating, always remember to behave courteously and non-confrontational. And that way, you'll maintain honor, you act in good faith, and you'll come with clean hands. So that's just the quick introduction, the basics of law. And we'll leave that section of that.
Good. Have you got anything that you wish to use as a real life example?
As a real life example, how about COVID-19?
Well, exactly. I think that what I'm saying there is, if you want to elaborate a little bit on the two things you've discussed today and put those into real life scenarios. And
I think that's actually a good point, because if we discuss now the COVID-19 very briefly in the context of the lawfulness of COVID-19, that's the real value example of what we're talking about here. So if we look at COVID-19, okay, and just take it very, very simply. Firstly, there's a claim that a virus exists called SARS-CoV-2 and that it's identifiable, it's unique. Secondly, the second claim is then that this virus causes some unique harm, or does it? And thirdly, the claim is that this is transmissible. So I just want to keep it really simple at that. So with that being, on the assumption that that's true, okay, to control the transmission of it would be a legitimate aim. So how do we decide if this is actually lawful or unlawful? Quite simply, we require that the claimant needs to prove their claim. Remember, we're innocent until proven guilty. We looked at that in the first module. So they need to provide the claim. Now who is they? They is anybody that breaches your peace. So if anybody asks you to wear a mask, as a parent, you're the guardian of your children until they're 18 or married. And so the vaccine, again. So legitimate aim if they can prove their claim. However, there's no scientific evidence that I've seen yet that SARS-CoV-2 exists. We've got admissions from the Cabinet Office, from the House of Parliament, House of Commons, House of Lords, Public Health England and Department of Health and Social Care that there's not been an isolated virus of SARS-CoV-2. There's nothing unique, no unique RNA by which you can conclusively identify this as SARS-CoV-2. Secondly, there's no record that of SARS-CoV-2 causing COVID-19, and COVID-19 has no unique symptoms. So these admissions are basically saying, on the second point, you do not have a possible claim for your legitimacy, i.e., by your own admission, you said there's nothing unique about SARS-CoV-2 that can be identified. It's never been isolated. It's never been shown to cause COVID-19, and therefore it means that there is no legitimate aim. So on points 1 and 2, automatically all COVID-19 regulations are unlawful until the claimant proves their claim, and then proportionality obviously isn't even an issue because the measures depend on transmissibility. But to determine transmissibility, you first actually need to establish the cause. So all COVID regulations unlawful until the claimant proves that it exists.
Which, just to confirm on what we were saying yesterday, is that's why we must be careful what we actually say to any law enforcement person. It is your job to prove that SARS-CoV-2 exists. What we don't want to be doing is saying to them it doesn't exist, because then obviously we need to prove that it doesn't. I'll bring this meeting to a close then, to probably actually simplify this in the greatest of detail. See you at Nuremberg Part 2.
Well, by then they'll learn about it.
Indeed. Thanks, Mark. See you on the next day.
Great.